Okay, well, we've already introduced ourselves, so we know each other. Thank you for coming today. I hope that at the end of our time here that we're going to take a break at about 10 o'clock, about halfway through. So because I've just pushed my cell phone under the door, I'm going to need one of you to tell me, Dwayne, breathe, let us go out and do something. This is very informal. If you need to get a drink or do something, then just get up and do it. This is nothing fancy today. I took a moment or two to introduce myself already, so I'm not going to do it again. You won't. I'm sure you're not going to go when you get this video. You're not going to go, oh, I want to hear what all Dwayne's awards again. That's probably not what's going to be most interesting to you. But I guess I'll open it up for first opportunity for a question. Raise your hand anytime we're talking if there's something I've said that you haven't understood. If you have a particular hypothetical scenario that you'd like to run past, that's why we're doing this in a group setting rather than just one-on-one. Because I found when I teach other attorneys consumer bankruptcy law and debtor-creditor relationships and negotiations, and I do it in groups because if one has a question, the other ones probably learn from that question as well. But if I do it one-on-one, then I've lost that opportunity to have that same information passed by just one explanation. So if you have a question, raise your hand, I'll call on you. Does anybody have a question about who I am, where I come from, what I do, why I have any credibility or authority to be hosting an intimate seminar with you? No? We're ready to go? Okay. Let's jump off with, first of all, we have a continuum. When we talk about debtor-creditor relationships, there's a continuum. There is, maybe we can just pay them off, write a check for everything we owe them. Now, that's not normally the case for people that come and speak with me, but then there's a possibility of negotiating a settlement, and that happens quite often. You know what? I started the continuum too far off. One end of the continuum is you don't have to do anything because you don't have anything. Nobody can do anything to you. If you're on Social Security disability, no creditors can take that income from you. Not before it gets to you, not after it gets to you. It's protected. So that's called a judgment-proof debtor. Then there's folks that we can pay everything a dollar on the dollar. Maybe we can pay everything dollar on the dollar. We just can't afford to do it all right now. So that would be some sort of a payment negotiation. Then there's a debt settlement. And when I talk debt settlement, I'm talking about something different than what you hear on the radio. These debt settlement companies that are out there aren't going to be your friend. Most of them have their thumb put on them by the FCC because they had to create an entirely new regulation because that industry was taking advantage of so many consumers. Here's the short scenario. They would say, hey, come in, if you owe credit card debt, let us settle all those with your creditors. They'll meet with you. Then they'll say, okay, we see your budget, your income, your expenses. You've got, it looks like $800 a month disposable income, but you need $1,500 a month to be able to take care of all these creditors. So why don't you pay us $800 a month? We'll save it all up, and when we have a lot of money saved up, we'll go make a settlement offer out to a creditor. Maybe you have a $10,000 credit card creditor. And so we'll offer them $4,000 and see if they'll take it. And if not, we'll move to another creditor. Well, the problem was they were taking that $800 a month, and for the first 5 months, they were taking their fees right off the top. And then what happens once somebody has been paid for something? A painter, a concrete guy. I mean, this is my own personal household experience. Once we paid a concrete guy in full, we never saw him again. It was like, boy, that was dumb. So we don't do that anymore. We had what we call experience. I learned years ago that experience, the definition of experience is that commodity that you needed, that you acquired shortly after you needed it most. So bottom line is, even in the bankruptcy arena, the trustees tell me there are cases that are called paid in fulls. And once someone is paid in full, it's unfortunate. It's not the right way to do business. It's certainly not ethical, but their interest declines in really resolving your debt settlement once they've been paid in full. And that's how the whole industry worked. So now they can't receive that like that anymore, and a lot of these fly-by-night, you don't hear them advertise on the radio as much anymore because they can't rip people off and use all the money to pay for advertising. Okay. So debt settlements, there is a legitimate debt settlement. I had a young woman who came into my office. She owed 3 or 4 creditors. She didn't need a bankruptcy. She had a good income, but the creditors were just leaning on her real hard. And so she went and she had hired a debt settlement company, and I explained to her that she didn't need a debt settlement company, like what I just explained to you here. In a matter of 45 minutes, She had her bills with her. We had called. We had negotiated settlements with the creditors. It wasn't anything that she couldn't do on her own. I do debt settlement negotiations, but you can do it too. Anybody can do it if they know how to approach the creditors and what to say and what to do and what not to say and what not to do. And I'm not talking about lying or cheating or saying something. You just choose your words carefully. Well, not so much in October, but this past month I had 4 or 5 debt settlements, and it's time consuming. That's why I prefer my clients to be able to do as much as they can. But sometimes they just say, I want this resolved. I have to do my job. I want you to do your job, and then they hire me to do debt settlement negotiations. It can be done legitimately, but don't go looking at those folks that advertise nationally. Then there's what's called a debt management plan. When I first started practicing, there had been organizations out there called credit counseling services that were real credit counselors. And they had been set up by banks in the 40s and the 50s and the 60s to help people interface with the banks. And somebody would sit down and do a budget with them and show them how to shop for food and how to say no to purchases and these types of things. And they were legitimate. I referred a lot of clients over to credit counseling services. Arizona had credit counseling services of the Southwest. They were very good. They were part of the National Federation of Credit Counselors. And if someone was going to another state, I'd send them to a National Federation affiliate. About 1997, 1998, they started getting bought by for-profit organizations. And that's when you heard the proliferation of advertising for those types of groups. And they're still out there. Do you owe $10,000 or more in credit cards? We can help. There's a group in town here. Well, it's national, but it's located in town here out in the Northwest called, darn, I can't think of it right now. I consider it Take Charge America. And they're legitimate. But how they work is if you pay them that $800 a month, then they'll make a debt payment out to all your creditors based on a negotiation that they've done, and they keep like $50 a month, and it's also not anything that you couldn't do on your own if you were qualified for it. If I'm over the road driving in a truck, for example, it's going to be difficult for me to interface with Take Charge America with all my creditors. So I might hire a Take Charge America just to have the relief. Okay. The next item on the continuum is a Chapter 13 repayment plan, which is a reorganization for individuals. You've heard of Chapter 11s, and Chapter 11s are available. Let me back up a little bit. In the library at Arizona State University, there is a room that's called the Arizona Room. It has all kinds of Arizona laws, and then there's a room that has federal laws in it, and there's a bookshelf that has, the whole room has regulations on how they run this country, but there's a whole bookshelf that has the United States Title 1, Title 2, Title 3. They're a book. You just slide it off. Well, for example, Title 15 are the criminal laws. You push that back. Title 26 are the tax laws. Push that back. Title 11 is the bankruptcy code. And in Title 11, it's a book. When you open it up, there's some administrative chapters, Chapter 1, Chapter 3, Chapter 5. Chapter 1's definitions. Chapter 3 is administrative, how the courts and the professionals work in the system. Chapter 5, pretty much the debtor's duties and property of the bankruptcy estate. Then we get into what are called the substantive chapters. Chapter 7, that's where you hear Chapter 7 bankruptcy. Chapter 9, which is for municipalities. If City of Mesa had to file bankruptcy, they'd file a Chapter 9. Orange County filed, Bridgeport, Connecticut filed, City of South Tucson filed at one point many years ago. Most recently, Detroit filed bankruptcy, and there's rules set up on reorganizing for those municipalities. Chapter 11 is another one that you hear about all the time. That's what happened with the Coyotes. That's what happened with Sears at one point. That's what happened with the airlines, America West Airlines, and it's the big boys. But because of this great recession we've been through, there have been some families and small businesses that have needed to utilize Chapter 11, even though they're not big boys. The problem with Chapter 11 is it's so darned expensive that most people can't afford it. They either liquidate. They might liquidate it under Chapter 7. Chapter 13 is for individuals. A reorganization, it's technically called adjustment of debts for individuals with a regular source of income. For you, that means a partnership can't file Chapter 13, a corporation can't file Chapter 13. You have to be an individual. You have to have a regular source of income from whatever source. I had farmers. They had one paycheck a year. It was still a regular source of income. They still qualified for Chapter 13. But most people have a paycheck every couple of weeks, or they have a small business. Even though the income goes like this, they still have a regular source of income. And it's an adjustment of debts. The history of bankruptcy, current bankruptcy. I'm not going to go way back, but the current bankruptcy system we used was enacted in 1898 with major revisions in 1936. Why would there be a major revision in 1936? This is your chance to participate. The Depression, right. Before 1936, individuals could liquidate, companies could liquidate or reorganize, but individuals couldn't reorganize. So Chapter 13 was enacted in 1936. 1978, there was a major revision of all consumer bankruptcy laws. When I say consumer, I'm talking about us, people, And what it made consumer bankruptcy much more friendly than it had been before, and it made it more approachable, so more people felt comfortable about either reorganizing their finances or getting a fresh start. 1994, there was some changes, the Omnibus Budget Reconciliation Act of 1994. But all you need to understand about 1994 is that there was a funding that happened to allow there to be a review around the country to see how bankruptcy laws were working. And they came back and they said by 1997, bankruptcy laws are working just fine. Visa International, however, thought, you know what, let's take that and tweak it, and let's say that the sky is falling. Let's be Chicken Little. And they started screaming that with their own models and their own statistics, and that's what gave rise to the 2005 consumer bankruptcy law changes, which were pretty dramatic and really are where we are today. There have been no significant changes other than cases that keep coming down that have worked their way up through the appellate process. So that's the history of bankruptcy law. I didn't get to the very final end of my continuum. That's Chapter 7, liquidation. I prefer to use it as a club to get people to come to the negotiating table. But there are people, there are times, there are finances, when we get in and we incur obligations intending to repay them, we just can't. We still have to take care of our families. The gauge that I use to determine whether or not I'm going to file a bankruptcy is my health affected dramatically by my debt situation? Are my relationships affected dramatically? And do I have the ability to provide for my family in spite of the garnishment or the lawsuit or whatever else? So I use that same standard when I speak with my clients. I look at them and I ask, I don't ask them, but I try to determine, is their health being jeopardized because they're laying awake at night, worrying about things, not feeling out of control? Are their relationships? I was speaking with another professor as we were getting ready to teach a class next week, and her law firm does some domestic relations or divorce work, and she just indicates that it's as we discussed it was hard for us to determine whether or not financial problems created the domestic problems, or if domestic problems, for example, now running two households on what you could barely support one on before, created the financial problems. It's a chicken and the egg, and we just determined that it's a case-by-case basis. You can't tell. It's sad. It's difficult. It creates a tension for the household and for the finances and for the kids, and it's just in 25 years, I've not found any way to feel anything but just a big, dark cloud when I go over to the domestic relations court to explain to the judges what bankruptcy means to them, what the automatic stay that we'll talk about in a few minutes means to that court, what things can they rule on, what things can't they rule on because the husband or the wife filed for bankruptcy. But as I sit there waiting for my hearing to come up to test or to explain to the court, I watch 2 or 3 hearings, and I just always walk out of the building with just a stupor. It's just a black cloud. Okay, so Chapter 7 liquidation bankruptcy proceeding, there is a time for it, and I measure my clients based on whether or not it affects your health, your relationships, your ability to provide for yourself and your family. Okay, that having been said, let's jump into just, first of all, the basics of bankruptcy is we're dealing with debts that have been incurred either as a secured debt or as an unsecured debt. A secured debt means you pledged collateral on that debt. An unsecured debt is something like a medical bill or a utility bill or a lawsuit or judgment where they just had a credit card or a credit card that moves to a judgment. Secured debts are things like Creditors are secured on our house with a deed of trust in Arizona. Creditors are secured on our cars with a lien on our car at the Department of Motor Vehicle. They're also secured on what's called a purchase money security interest. If I go to Sears and I use a Sears credit card, which is really a Citibank credit card, and I buy a refrigerator there, the creditor knows that I bought a fridge. So that refrigerator is collateral on that Citibank card. As opposed to if I went in with a Discover card to Sears, which isn't affiliated, they don't know what I bought. In order for a creditor to be secured, they have to be able to specifically identify the asset that I purchased with the money. If you go to a Best Buy or a furniture store, it's usually going to be GE Capital that is going to be the secured creditor. And all that means is you've pledged that asset as their asset to the extent that they can't collect on the promissory note. So think of any debt as a promissory note. I, Dwayne, promise to pay whoever. Let's say it's Discover card. Let's make it something that's not a revolving credit. Let's make it I'm purchasing furniture. So I, Dwayne, promise to pay GE Capital $1,500 for a leather couch and a love seat and a dining room table. Not dining room, a coffee table. If I fail to pay, I'm pledging these assets as collateral. If I fail to pay, then you can repossess or take possession of those assets. I sign it. Now we have what's called a secured transaction. If I can't afford to pay for on that promissory note, I messed that up. Let me start again. Erase. I was going to do two pieces of paper. One is a promissory note. I, Dwayne, promise to pay you $1,500. The other is a security agreement that says I pledge my car, my house, my furniture as collateral. They're two separate types of legal interests, but they're always merged on the same document, especially if it's a car loan, right? Little onion paper and it's as long as your arm. I have no idea why auto lenders still, or auto dealers in a day of 8.5 by 11 photocopiers still use onion paper that's 14 inches long. If I were to file a bankruptcy, let's just fast forward real quick, and if I file for bankruptcy, I can discharge my promissory obligation usually, and we'll talk about some non-dischargeable items, types of debts in a few minutes. But security interests survive bankruptcy. They have since 1898. So that's why we have to treat them differently in a Chapter 7 or a Chapter 13 than we treat other creditors. Any questions on secured transactions? No? Yeah? Okay. Is it all crystal clear? Or are you going, dang, I wish I'd have spent my Saturday morning listening to Rosie on the House? Not yet? Okay. Debt relief alternatives, we've already covered that. We haven't talked about players. We'll do that very, very quickly. There's a bankruptcy judge. The bankruptcy judges in Arizona just swapped out. I don't think there's a district in Arizona that has had the movement of from 7 highly experienced, tenured bankruptcy judges to there's 1 tenured bankruptcy judge and 6 brand new judges. And boy, it's hard for me to sit across the table and explain to folks what's going to happen, because in a judge, whether it's bankruptcy judge or family law or civil court, the judge gets to determine what the procedures are in his or her courtroom and what they think the interpretation of the law is. Now, they're bound by Ninth Circuit precedent or district court precedent. But other than that, they're not bound by some other court somewhere else in the country, even if it's well litigated and logically laid out. So the bankruptcy judges, here's what I found. I don't know this class as well as the other ones, but the bankruptcy judges I practiced before have been ladies and gentlemen, and they're just extraordinarily capable jurists. So when you get into the federal bankruptcy court, you don't need to worry about some crazy judge like you've heard in some other court somewhere. I won't pick out any court, but there's some people that there are some people appointed to the judiciary that operate by fiat a lot in their courtroom, and that's not the bankruptcy system. Bankruptcy trustees are appointed. There is a U.S. trustee for the District of Arizona. She hires standing trustees. The trustee is the person who's responsible to manage what's called the bankruptcy estate. And we'll talk about the bankruptcy estate in a few minutes. The bankruptcy estate basically consists of all of your property, less your exemptions, which we'll talk about in a few minutes. The bankruptcy trustee's job in a Chapter 7 is to liquidate. That's what a Chapter 7 is a liquidation. Take assert control over assets that are not protected, turn them into cash, distribute those proceeds out to your creditors. And if we get a minute or two to look at the handout that I gave you that I use with the law students at the law school, I show how the bankruptcy estate and basket works and what the trustee's responsibilities are. Also in the players, there's the creditors and their attorneys, and there are debtors and their attorneys. The creditors and their attorneys, the creditors' attorney's job obviously is to protect the creditor's interests. Bankruptcy is much more debtor-friendly than it used to be 100 years ago, but there are still rights that creditors have to be treated equally among their class. We've talked about secured creditors versus unsecured creditors. Within a class, you have to treat a creditor equally. There are priority creditors we haven't talked about, and it's a different classification of creditor, like child support or certain taxes or employees that you've had recently that didn't get paid. So a priority creditor gets paid before an unsecured creditor does. But within the class of priority creditors, they have to be treated equally. Debtors' attorneys, that's what I've been doing for 25 years, and I use an example in a video that Noah and I shot earlier this week. On Labor Day, my family was in Sedona, and we were hiking along a little trail. And that weekend, my oldest son and my youngest son and some of us were discussing whether or not we were doing a lot of hiking in Sedona, and whether or not the rattlesnakes were still out. And I was a scoutmaster for 7 years. I'd have an outing once a month with my boys. And so, I kind of paid attention to that for a while. And no, it was still warm enough on Labor Day for the rattlesnakes to still be out. Well, we're coming back on Red Rock Crossing, and we've been splashing around in a little pool for a while. And my youngest son, whenever we're on hikes or campouts, he's always in front. But he comes back and he's holding his heart, and he looks pale as a ghost. And all he could get out was rattlesnake. And there's one that was right on the trail, but he hadn't bothered him enough. He kept going off the trail. And by the time I got there, he was off the trail, and the rattlesnake, I don't know if it was a male or female rattlesnake, but the rattlesnake was wound into a complicated mess of brambles. And my oldest son, who used to always stay and mess with rattlesnakes with me, he had 2 babies with him. I'm sure his wife had something, but they were gone. They weren't sticking around, and my wife was gone, and my youngest son was gone. So I'm there by myself trying to have fun with this rattlesnake like an idiot. But I saw an opportunity to grab a rattlesnake's tail, which normally is just a really stupid thing to do. But it was a big rattlesnake and a big rattle, and so I grabbed his tail, and of course it made him really mad. But the reason I felt comfortable grabbing the rattlesnake's tail is because he was stuck in a complicated mess. Why do I tell the rattlesnake story? Why did it become a subject of a video earlier this week? Is because bankruptcy is a complicated mess that people who file on their own don't realize what they're getting into. It is a sticky wicket. There's lots of little rules. At least this type of training that you're doing, whether you're here for information to help yourself or to help someone else, this type of information and training is real important. We're going to try to hit some of the highlights, and I'm going to speak in a few minutes about timing, and that the timing is one of the stickier wickets that we deal with. Okay, debtors counsel, automatic stay. The automatic, yes, we have a question.
Did you get the tail?
Oh, I didn't take the tail. I didn't want to hurt it, but I grabbed it. Yes, it was an adrenaline rush. Then I jumped back. Then I ran and caught up with my family. I wasn't going to stick around because he was mad at that point. But no, that was, as an old Arizona desert guy, that was kind of fun adrenaline experience for me. So, automatic stay. When we file a bankruptcy, creditors have to back off automatically. And this automatic stay is very, very important. It didn't always exist. Before the 1978 version of the law, incidentally, nothing we've talked about so far today other than the little stuff we talked about before we fired up the video. None of the stuff is, there's a reason why, I'm not just sharing stories for Old Home Week and for you guys to hear Dwayne's stories. There's a purpose toward. But that's why I explained the history of bankruptcy like you'd ever need it. But 1978 Act, before that bankruptcy code, there was the Bankruptcy Act. And it was just a disheveled bunch of laws all over the United States law books. And they were brought together in 1978 into what was called the code. Before the Bankruptcy Code in 1978, if you filed a bankruptcy, not a trustee was appointed, but a referee was appointed, and creditors could still call you and harass you and come to your home and threaten you. And what you had to do was file a motion with the court to impose the automatic stay. But by the time you got a hearing in front of a judge, they'd already had their fun. They'd threatened you. They'd gotten some more money. They'd convinced you that the bankruptcy wasn't going to help you. I mean, and so Dennis DeConcini from Arizona was a freshman senator. He was given this little committee to chair. It was the Bankruptcy Reform Committee, and he ran with it. And he had hearings on Capitol Hill. And at those hearings, the debtor's side, which was me, but I was still in high school, would come up and say, hey, look, we need an automatic stay to go into place because creditors are abusing, the debtors. And the creditors would come and say, no, there's real important information that we need. Don't impose an automatic stay because there's stuff we still need to find out about. Where's our collateral? Did you file a plan? These types of things. Well, in Congress's wisdom, they imposed the automatic stay, but gave the creditors an opportunity to come and ask questions and to get information. It's called the meeting of creditors. It happens about 5 weeks after we file the bankruptcy. And surprise, surprise, creditors never come. They didn't need, there wasn't a lot of information they really needed. They were using that to advance their position of let us keep having our fun once the bankruptcy is filed. So what does you know what automatic means? It happens automatically. A judge doesn't formally come down and say, okay, well, this is Dwayne's bankruptcy. We're going to impose a stay. No, it's just automatic. The clerk of the court sends out a notice to everybody. When we file a case for someone, we actually contact the suing creditor or the creditor's attorney, really. We contact the threatening repossession company or whatever and tell them there's a bankruptcy that's filed, stop the garnishment, don't repossess, don't continue the lawsuit. We file a notice with the Justice Court or the Superior Court that tells the court, don't move forward at this point. Federal court supremacy, the United States District Court with a subdivision of the Bankruptcy Division, has issued a stay. You guys can't do anything. That's why I'm across the street with the Domestic Relations Court explaining there are some things you can do. For example, you can declare a husband and wife no longer married. The automatic stay doesn't, nobody should have to be forced to, the judge's hands in divorce court shouldn't be bound of separating a union if that's what the parties want. But they can't divide the property because that's subject to the bankruptcy estate. Okay, the automatic stay, you know what a stay is. It keeps people from doing things like an injunction. I have a next door neighbor, wonderful man. He has lots of orange trees in his yard, and he has a horse. And I have the right to walk up and down my street. But if I pick an orange off his tree and chuck it at his horse, which is an inhumane thing to do, I'm not advocating that, just for disclaimer, and I'm not responsible if you start doing mean things to animals in your neighborhood. If I did that, he would have the right to go into the Justice Court and file an injunction, and the judge would issue a stay and say, Dwayne, you can't walk up and down your street anymore. You used to be able to do that. It was legal, but now it's illegal. Don't do that. Now, restraining order is really a lot more serious than Dwayne picking fruit and chucking it at an animal. It's usually domestic abuse is where these things come from, or stalkers or things like this that, we don't even have time to talk about that. But so an injunction or a restraining order is a stay. An automatic stay keeps creditors from continuing lawsuits, continuing garnishments, unless it's for child support. There are exceptions to the stay. It keeps them from repossessing items. It keeps them from calling you at all. Now, I'm not talking about. Remember this group of laws that are on the back, that are on the shelf at the federal, at the ASU Law Library, the federal laws in the federal room. If you pull. I got that wrong. I think I pulled Title 15 off and called it the criminal law. Title 18 is criminal law. Title 15 are consumer laws. For example, the Fair Debt Collection Practices Act, meaning including creditors can't call and threaten you. Creditors can't call and say they're going to do something they don't intend to do or they legally couldn't do. Creditors can't call before 8 in the morning or 9 o'clock at night. They can't be harassing. If they violate the Fair Debt Collection Practices Act, it's a per se violation, which means they're liable. They're going to have to pay your attorney's fees, and they're going to have to pay you $1,000 for having violated that law. You usually need a recording or something that's other than just he said, she said. When we were doing the debt relief show, part of the preparation for the show, for our show on the Fair Debt Collection Practices Act, we obtained a recording from a Los Angeles radio station where a debt collector who represented a lender who had lent based on a mortuary's final arrangements. I'm losing my words. What is it? The expenses for a casket and burial and services and everything else, whatever that's called. They financed it. The woman did not have the money to pay for that, so they financed it out. And this is like 2 or 3 months later. It's already been turned over to collection. That's because she wasn't paying, but she couldn't afford to pay. I'm not saying that she shouldn't have paid if she had the ability to pay, but the abuse that she took, she had a recording. They were abusing her greatly, but she recorded one. And the recording we got from the LA radio station was, hey, this is Mac from, ABC Memorial. I don't want to name somebody and defame somebody, but and if you don't pay us, we're going to dig your dead daughter up and hang her from a tree in your neighborhood. Now, that's a violation of the Fair Debt Collection Practices Act, one of the most egregious we could find. It can be I have clients come in all the time who say, a single mom who says, I'm here to talk to you because the creditors have told me that they're going to have CPS take my children, or they're going to have me arrested. That's not ancient history. A colleague of mine sent me a letter that basically looked real official. This is 2 weeks ago, looked very official, and what it said was that we have the authorities we've contacted the authorities and they're going to come and arrest you for this civil violation. They owed money. You don't go to jail for owing money, unless you owe it to the court for traffic citation and you don't show up or something like that. But first of all, when it's a civil obligation, you are not subject to criminal prosecution. You're not subject to the police coming and arresting. You're not subject to, you shouldn't be subject to the types of threats that are only to get you to send them money. Okay, so the automatic stay precludes things much more than just the Fair Debt Collection Practices Act precludes. The automatic stay allows the debtor to get some relief, to get some time to think things through. I've had some complicated times in my life where I wasn't capable of making the right choice or the right decision. Life is a series of choices. And if we make some choices that go south, we can recorrect. But if we're not in our best state of mind, either health-wise, relationship-wise, just complicated life-wise, it's hard to do the right thing to point your future to where you really want it to be. That's what the automatic stay is all about. So, are there any questions about what creditors can or can't do once a bankruptcy is filed as regards to the automatic stay? Generally, they have to deal with me for my clients. Or if someone is representing themselves, then they can still contact the debtor, but they have to be very careful about what they demand or what they say. Normally, what a creditor is able to do is file a proof of claim and then ask the trustee in the court by filing motions or requests there. They shouldn't be making a lot of contact with the debtor. And if any contact is made with the debtor, it needs to be for things like there's a piece of collateral that you've indicated that you're going to surrender in the bankruptcy on your statement of intentions. Do you want to reaffirm on that, which we'll talk about later, or do you want us to come and pick it up? Okay, so the automatic stay is a very powerful part of what bankruptcy is all about and why people file a bankruptcy. Assets. When we file a bankruptcy estate is created. So now I'd like you to turn and go ahead and find this page that says Chapter 7 and Chapter 13 on it. And at the very top, I've indicated that there are assets which are either exempt or they are non-exempt. It's like a toggle, on or off, right? I'd like you to turn now and find the sheet of paper that says exemptions, and it has Arizona exemptions written at the top. We're going to come back to discussing assets in general, but Arizona exemptions, I need to explain what exemptions are for a moment or two. And then we're going to come back. Because it's a toggle, everything we don't talk about here is non-exempt, and that means it's exposed to your creditors. If we were, let's talk about exemption simply means that the property is not subject to legal process. It is exempt from legal process. Let's go back in history. Let's say we were in 1749 England. Why do I go to England? Because our common law system has come and derived from England, with the exception of Louisiana, which is the Napoleonic law, which is, if you go to Louisiana, just expect everything to be different. I see a big smile back here. You've been to Louisiana. Okay. So in 1749 England, if I had borrowed money, and there wasn't consumer financing back then, I would have borrowed it for a business purpose. If I had borrowed money and my business failed, then the creditor could file a lawsuit against me and get a judgment against me. And with that judgment, they could come out to my hamlet. And let's say they got a judgment for £5. I had borrowed 3.5 pounds, but with interest and costs and penalties, now they have a £5 judgment against me. They come out to my hamlet. They can take my home, my mule, my feed grains, my food supplies, my furniture, my clothing, tools of the trade. Literally everything was subject to execution. Execution meaning legal process to take. Somewhere along the line, I imagine that Parliament got tired of seeing naked people running around. So they said, okay, creditors, new rule. You cannot take clothing. And then a few years later said, we're tired of feeding these people's kids. You can't take their food supplies. And later on, you can't take their tools or their trade. And then the list grew and grew. All you need to understand is that in Arizona, anything that you own that is listed on this sheet of paper is exempt. And anything that you own that's not listed on this sheet of paper is non-exempt. Okay? This is the list of exemptions in 1749. This is the list of exemptions in Arizona. It changes district to state of stuff that's protected. And what we're talking about here is the equity in stuff. Now, this is not a bankruptcy law. It applies in bankruptcy, but this is a state debtor-creditor law. We are here in the same building as the North Mesa Justice Court. And there's a constable for the court. He's a fine man. I call him Andy because he's like Andy Griffith. He goes out and does dangerous things and he never carries a gun. Okay? But they do assert control over non-exempt assets, things that aren't here. He's sat right about here in this room, and we've had a discussion about what it takes to evict someone from their home and how he handles it, and he has a very humane way of doing that, and what it takes to assert control over non-exempt. There's a balance between, the creditors have rights, and that balance is if there's something that's non-exempt, we don't want them rushing into a household to assert control over stuff. We want them, creditors, using the process of the constable to go out, because the constable will be an objective third party to determine, yes, this is exempt, no, that's not. Like I mentioned, a couple years ago, I wrote and redrafted Arizona's exemption law, and I was able to get it introduced in the Arizona State House, House of Representatives, and then we moved it over to the Senate, got some pushback from the U.S. trustees, bankruptcy trustees, but we were able to get it passed, and it greatly expands what people inside of bankruptcy or outside of bankruptcy are able to protect. What can you protect? You can protect up to $150,000 equity in your homestead. That's a site-built home, or a condo, townhouse, or a mobile home, or manufactured home, and the land upon which the mobile home resides. The purpose for that is people shouldn't be homeless because they made a financial decision that didn't work out. And we saw a lot of that in the 2006 to 2011 period of time, where a lot of homes were lost. But the homestead exemption was able to protect some of the homes where they weren't upside down. We can protect motor vehicles up to $6,000 equity. What does this mean? If you own a car that's worth $6,000 and nothing is owed on it, there's $6,000 equity. The constable can't come and take it, or if you file for bankruptcy, it does not become property of your bankruptcy estate. It's exempt.
What if it's worth a little more?
Okay. Do you owe any money on it?
No.
Okay. If it's worth $9,000 and you owe nothing on it, how much equity is there? $9,000 equity. They can come and assert control over the vehicle, and the constable would sell it, give you the first $6,000, and then keep the other $3,000 to pay your creditors. If it's a husband and wife, we can stack the exemption. So $6,000 for the husband, $6,000 for the wife, we could protect a vehicle worth up to $12,000. Now, there is another exemption for people that are physically disabled or have dependents that are physically disabled. And the exemption for them is $12,000. They can protect a vehicle worth up to $12,000 equity. Now, the reason I ask you if there's anything owed on it, because most of us have cars with money owed against it. Let's say the car's worth $9,000 and we owe 12. There is no equity because remember, this line is what shows equity. If you owe $7,000 and it's worth $9,000, there's only $2,000 worth of equity. The exemption law will still protect you against your general creditors, but in order to keep the vehicle, you've got to keep paying that creditor that you owe $7,000 to because you pledged it as collateral. Remember, I indicated that secured creditors have the highest rights in the bankruptcy system. Okay. Did that answer your question? Okay. Is anybody confused on the whole concept of equity? And okay, good. We can exempt personal property or household goods. Let me do that again. There's two types of property in the world. There's real estate, which is real property, and there's personal property, which is everything else. If it's not bolted to the ground or cemented in, it's personal property. We can protect certain forms of personal property, like household goods, furniture, electronics, and appliances, up to $6,000. This is Arizona law, up to $6,000 per individual. Husband and wife. It used to be before we changed the law, that you could protect 17 specifically enumerated items: bed, dresser, coffee table, end table, couch, love seat, washer, dryer, refrigerator, stereo, television. You could protect an antique dining room table because it's on the list. But if you had a hutch, you couldn't protect it. So we went through, we just got rid of all the specifically enumerated items, and anything that you own that is a household good, furniture, appliance, electronic, is protected up from your creditors, the constable or the bankruptcy trustee, up to $6,000. Now, there's a fine line between what's a household good. Just because it's in your home doesn't mean it's a household good. For example, a firearm is not a household good. We keep it in our home. It's not protected. Now, there is a protection under miscellaneous property of one firearm up to $500. Tools of the trade used to be exempt or protected up to $2,500. We increased that. That was a 1982 number. We increased that in 2013 to $5,000 because stuff just costs more money now. That means if I start a landscaping business, I could protect my mower and my trailer and my weed eater and this type of stuff. Now, I'm an attorney, but there's nothing that says I can't have, in Arizona, that I can't have two trades. You're a truck driver, but you can have a weekend business, if it worked out, of being a handyman. And you could protect your handyman tools, even though you don't use them as a truck driver, to apply that second trade. If we're married, we can have a second exemption of $5,000. So that would be up to $10,000 worth of tools. That was real important because I have a lot of clients that are mechanics, and their tools are worth well more than $2,500 or even $5,000 if they're stacking the exemptions with their spouse. The spouse does not have to turn a wrench. So if a husband has tools of the trade that were $7,000, but he's only entitled to protect $5,000, his spouse, who has a job at an insurance company, can still claim an exemption in those Snap-on tools, simply because it's part of their marital income. Okay. Miscellaneous property. We can protect clothing. That was my first example from 1749 England. We can protect up to $500 worth of clothing, musical instruments, $400. These are all stackable, by the way. Wedding rings and engagement rings, they were only protected up until last year up to $1,000. Well, that was a 1982 number. We were having some folks that were really worried about their rings because they were worth more than $1,000. We can exempt a burial lot up to $1,000, and food, fuel, and provisions up to 6 months' supply. Whatever your family would need would be dependent upon the size of your family. We don't store gasoline in our home anymore, but if we had lumber chopped up, what's that called? Firewood. If we had firewood chopped up, we could protect a 6 month supply of firewood. We could protect 6 months supply of food, pantry items, and food storage items, these types of things. How are we doing on time? What time do you have, Noah?
9:56.
Okay, so we're going to go about another 4 minutes, and we'll take a 5 minute break, and then we'll give you a chance to ask a couple questions. But We can protect, under Arizona law, $300 in a bank account, up to $25,000 worth of cash value life insurance. That means if you're gathering a universal policy or whole life policy, if you're gathering some equity there. Not a very good financial product, by the way. We can talk about that offline if you want to, but you can also protect $20,000 worth of proceeds of life insurance if somebody has passed away, but it has to be specifically, it has to be the proceeds. You have to be able to point to the proceeds. So if you have equity in a home, you can protect up to $150,000 equity in that home, but if you sell the home, the proceeds are only protected for 18 months. If you get into that scenario, please give me a call. Schedule an appointment to meet with me so I can explain to you how that would work in your case. We're having trustees in bankruptcy coming after those things because the monies aren't reinvested in another home within 18 months. We're having trustees come after things like a wrongful foreclosure settlement where a client got $31,000, not my client, but got $31,000 after the bankruptcy is all over with, and the trustees still thought they could come and take that. The trustees are getting very, very, very aggressive. So it's real important. This is that sticky wicket, this complicated. The reason I use the rattlesnake example is you don't want to be making decisions based on something you don't do all the time. I'd love to be a resource for you. Give me a call. I'd need to know more about your personal financial situation. Then I could advise you what I would do if I woke up in your shoes. Okay. You can exempt $2,000 prepaid rent or security deposits. I've left off a few things. You have the list here. Once you get home, you don't need me anymore. This list is, well, it leaves off some things like, I say certain pensions, so you do need me to talk about what type of pensions. The Arizona State Retirement System, teachers, police, fire, these are all completely protected. There's no exposure on them whatsoever. But with regard to private pensions, most 401ks are protected, most IRAs are protected. The reason I say most 401ks, another attorney in Arizona would say, Dwayne's lost his marbles. All 401ks are protected. Well, that is if the bank has done everything they've done to keep that 401k qualified under the rules, the Internal Revenue Service rules. There's nothing that we could do different. But if the bank has messed up, I've seen a couple cases from other parts of the country where the creditors have gotten real crafty and gone in and found that the requirements under 401k, Internal Revenue Service, Section 4, remember Title 26 I mentioned before, you pull that off the shelf, you get Chapter 4 in 401, Subdivision K, it talks about, private retirement plans. Okay, so where have we gone? We've kind of laid the groundwork on a lot of things, not got into any depth like we will in the second hour on things like Chapter 7 and Chapter 13, how they will work in your case. But we've established that there's a bankruptcy estate. We established that there are assets. Anything that is exemptable is protected. That's back on this list here. And anything that's non-exempt is not protected. So let's use my basket. If we filed for bankruptcy on November 1st, everything we own goes into this bucket. Anything that is exemptable, you see this line out here to the left, your left. I don't know how it is on my left.
Right.
Your right. Thank you. I knew something was backwards here. To your right is the exempt assets. They come out of the bankruptcy estate. The trustee cannot administer them. The trustee cannot take them. Anything that remains in the basket you see down there is non-exempt assets, are non-exempt assets. And the ones that have any value to the estate are ones with equity. It doesn't matter if there's a non-exempt asset out there. If it doesn't have any equity, the trustee isn't going to want to take it and sell it because it won't benefit the creditors. Over here, you'll see the purpose of a Chapter 7 bankruptcy is to provide for a pro rata distribution out to unsecured creditors. Pro rata meaning if there's $1,000 worth of assets that are non-exempt, that have equity, and if there's $10,000 worth of claims, 1,000 over 10,000 is everybody, all the creditors would receive, or the unsecured creditors would receive 10 cents on the dollar, a dime on the dollar. Now that's in theory, that's in a perfect world. This is the part where I'm going to make some people mad, and I'm sorry, but greed is alive and well. I think it extends out to those who are administering bankruptcy estates, and I think they will find every way to spend every nickel that's in a bankruptcy estate for bankruptcy trustees' fees and the trustees' attorneys' fees. The reason I can make such a bold statement, it's not an endearing statement, is because I've seen it happen time and time again in my cases. I've heard about it happening in my colleagues' cases in Arizona, and nationally, I belong to the National Association of Consumer Bankruptcy Attorneys, and has been a trend in the last couple of years that trustees are just milking the estates. And the reason that's unfair is because then creditors are getting less or nothing at all. Okay, before we break for a break, and it'll be a short break, about 5 minutes, do you have any questions about what we've talked about so far? Okay.
Oh,
Yes.
well, you didn't talk about it, but you mentioned, there's something in here mentioned about, earned but unpaid wages is only 75%.
If you don't mind, we're going to push back the break for just 2 minutes because this is real important. Under Arizona law, and it's also consistent with federal law, creditors, if they get a judgment against us, can only take 1/4 of our net take-home pay. And that's limited as well. If you multiply the minimum wage at any time times 30, that's how much I get to take home, regardless of what the 25-75% split would be. So in English, instead of legalese, I'm guaranteed that I get to take home to feed my family, to pay electric bills, keep my car full of gas, maybe a car payment made or rent or mortgage payment paid. I get to take home 75% of everything I earn. Unless it's the Department of Revenue or the Internal Revenue Service that's collecting from me, or child support. Those three things have exceptions. Everybody else is limited to only being able to take 1/4 of my net take-home pay. Now, if there's a judgment, nobody can take any of my wages unless a judge has already determined that I owe them some money. So let's do the little lawsuit game for a minute, real quick. Someone wants to collect from Dwayne, and I owe them $10,000 in credit card bill, but I can't afford to pay it. I'd like to pay it, but I just can't afford to feed my family and pay it. So they try to collect from me for a while. I pay them something, but not much. They get tired. They turn it over to an attorney. The attorney files a lawsuit against me and serves me with a lawsuit. The worst thing I can do is bury my head in the sand and ignore it because they'll get a judgment against me for whatever they're saying is owed. So my responsibility as a citizen is to go and respond. Unless I agree with that, I can negotiate a settlement with. That's a great time to negotiate a settlement. But is to file a responsive plea and say, I don't know where they came up with the $10,000. I owed them $3,500 at one point, and now I understand interest and penalties, but let's see a calculation here. So the judge hears all of this, and the judge agrees that I owe them $10,000. The judge issues a judgment against me. Now, then they can file a notice of garnishment, and it's a levy on my wages. And it's a continuing levy. That's real important for you to understand. If somebody has a judgment against me and they want to get money out of my bank account and they levy my bank account, if there's only $10 in my bank account that day, they don't get anything. They'd have to levy at a different date, right after my pay period or whatever, to try to trap some money in that bank account. But if I'm working and my employer is served with the notice of garnishment, it's a continuing levy. It's as long as I'm working there. So that I have to hit it right at the right time. If I have a very slow week, the week that they hit, doesn't matter. 2 weeks later, if I had a really great pay period, they're going to get 1/4 of my take-home pay. I can go in and explain to the court how that issued the garnishment order, how it's going to affect my family, and I'm not going to be able to feed my family and pay the bills that I have. And sometimes the courts will reduce that down to 15%. Now, I have a client that was reduced 15%, but then there was another creditor who had a judgment, so they came in and got the other 10%. And so creditors have to line up like planes on a tarmac. Let's say I owed 5 creditors $10,000, the first one to go and start garnishing me is going to get paid in full out of that 25% before anybody else starts getting paid. But under Arizona law, 3/4 of my take-home pay is protected. How does that work in a bankruptcy scenario when I'm talking about, it's over here, when I'm talking about I file a bankruptcy and the trustee in bankruptcy wants my take-home pay? Once I file the Chapter 7 bankruptcy, the trustee can't assert control over anything other than the monies that were owed me on the day I filed. Why do we say earned but unpaid? Because it could be more than just that pay period's earnings. You could have a bonus that you've earned all year long now, and you're going to get it in December. It's kind of earned, or you could have sick days that have accumulated, or other benefits that have accumulated, commissions or whatever, that whatever's been earned but hasn't been paid by your employer on the day that you file a bankruptcy petition, 25% of that is exposed to the trustee and to the bankruptcy estate. Now, outside of bankruptcy, 25% is what the constable could, the court could have taken on a regular basis. When that bonus comes in, they can get 25% of that as well. Did that answer your question? Anything confusing? Okay, we're going to take a 5-minute break at this point, and the restrooms on time. Okay, we were discussing when we closed the last hour, we were discussing bankruptcy estates. When a bankruptcy is filed, a bankruptcy estate is created, I related it to a basket or a bucket. Everything you own goes in the basket, exempt property comes out of the basket, that which remains, that has equity is non-exempt, and the trustee can liquidate it and turn it into cash and use those proceeds out to pay to your unsecured creditors. Now, remember we talked about secured creditors, and I'm gonna, well, that's the liabilities. Go back to this sheet here. There's the basket. Then there's the liabilities. People we owe money to are either unsecured creditors, we talked about that in the last hour. They are secured creditors, which means we pledged collateral either consensually or by statute. Okay? Does anybody have any questions about what a statutory lien might be? Well, you know what a consensual lien is. I buy a house, I pledge, don't duck, just go through. Okay. If I buy a house, I grant a deed of trust, which is a 3-way relationship. Ready? I'll hold up 2 pieces of paper, and my pen can be the third relationship. If I'm a buyer and I'm buying a house, there's a bank and there's somebody who's selling the house. I want money from the bank to go to the seller so I can get title to the home from them, and I promise to pay the bank some money. If I don't pay them the money, there's a third party that is appointed called the trustee. And I give them, as the buyer, there I am, as the buyer, I give the trustee under a deed of trust, the authority to sell the home and pay the money to the bank if I default in certain terms of default. Now, the seller's out of the picture. I own the house. I've got the house. If I default on the payments, the trustee is that third party that will sell the home, pay the money to, and that's a consensual lien. If it's on a car, I give a deed of trust, I get a lien on my car at the DMV. They have self-help remedy. The lender, I want the car, I buy the car. I've got the car. If I don't make payments on it, then they come repossess the car. The same thing with the furniture that I bought from Best Buy or Sears. Okay, so our secured creditors are consensual. In a bankruptcy, we can either surrender a secured asset back, redeem the secured asset, or reaffirm. This is real important. Surrender, you know what that is. I've got a $23,000 car. Make sure I do this right. Worth $23,000. I owe $35,000 on it at this point. I'm having financial troubles because my wife lost her job and my income is cut because I no longer have overtime. I incurred that debt intending to repay it, but I no longer can. So if I'm forced to file a bankruptcy, then I have the option of surrendering that car. That deals with remember I indicated there's a promissory note and there's a lien. By surrendering it, I get rid of the lien. By filing bankruptcy, I get rid of the promissory obligation. Now, if I don't file for bankruptcy, I can still get rid of the lien obligation by surrendering the vehicle back to the creditor. But the promissory note is still there. On this example, I owe 30, I think I said 35, and it's worth 23. After they take it and sell it, I'll still owe them 13, 20, 35, 23, $12,000 in a deficiency. And deficiency, a lot of people don't understand that deficiency. That's promissory note is still there. They can collect on that deficiency whether I'm driving that vehicle or not anymore. Reaffirmation. Let's say that I could afford to pay for that vehicle, but I can't afford to pay all my debts. Then I would put myself back on the hook for the obligation. That's called reaffirmation. You really need to have someone negotiate that reaffirmation with you and for you, because there's things that you can do to take some advantage. It's in this example, the creditor's about to get a $23,000 vehicle back, and by the time they run it to a dealer's auction, they may only get $15,000, $16,000 for it. They're better off if we reaffirm at 25 and redo the interest rate and redo the payment terms. So there's some things that you can do in keeping that property. We don't have it in here, but this morning when you came in, we vacuumed with a Kirby vacuum. Have you ever held a Kirby vacuum? They weigh a ton. They're like a armored vehicle. I have personal opinion that after the Holocaust, cockroaches, scorpions, and Kirby vacuums will be the only things that will still be roaming the earth. But I own 5 Kirby vacuums. They cost $1,700 a piece if you buy them from the guy who comes to your door. But that's not where I bought them. And I bought them in the mid-90s, by the way. The reason I did is because I'd buy a vacuum and my staff or whoever is using it would have it destroyed in 9 or 10 months. So I bought something that could not be destroyed. I would go to those who repossessed the vacuums from people who couldn't afford to pay the $1,700 anymore, and they would sell them week in, week out for $350, $400. So I'm in court. A Kirby vacuum attorney was arguing that my client shouldn't be able to keep, we're talking about redemption right now. Sorry. Surrender, redeem, or reaffirm. I move topics in my mind without introducing to you. You know what surrendering is. We talked about reaffirming. In the middle, if we can afford to pay the fair market value of that asset in a lump sum, then we can redeem the asset because it makes the creditor, the secured creditor, whole with regard to what they would have gotten had there been a liquidation, a surrender of that asset in liquidation. Well, Kirby comes in and says the vacuum's worth $1,700. And I come in with my client and say, Your Honor, the vacuum's worth $350, maybe $400. And the Kirby vacuum attorney is just rolling their eyes. And Your Honor, we sell these all day long, every day for $1,700. And I said, Your Honor, I buy them. This is back when I was buying them. I buy them every time I want to buy them for $350. I could get you one for $350, Your Honor. And the judge, by the time I explained the scenario, they're only worth on the market as a repossessed vacuum. I was able to get the judge to agree that for $350 paid to the creditor, they satisfied the lien, and therefore they didn't have to pay the entire promissory obligation. It's called redemption. Okay, that's consensual liens. There are judgment liens and statutory liens. Very simply, if somebody gets a judgment against me, they record it in the county recorder's office. Before I sell my house and get any money out of my house, they're going to get paid because there's no way that the title agency that's issuing the title for the buyer is going to allow them to have title that has a cloud of some judgment that Dwayne has. So they're going to make Dwayne address that judgment before the closing. A statutory lien is very simply, there's certain things that automatically attach as a lien. If I owe taxes to the federal or state governments and they make demand and I don't pay it, then they can issue a lien against everything that I own. If I take my car to the mechanic and he fixes it all up, and then I say I don't have the money to pay you for it, he has the right to keep that car until I pay it. It's called a mechanic's lien. There's also what's called a materialman's lien. If a lumber dealer, there's a lumber dealer over here called R&K Lumber. If they supply the lumber for a house that's built in Gilbert, and then something goes wrong, and lots of things could go wrong in a real estate transaction. Let's say they're not building it's an addition, right? And something goes wrong with the financing. R&K has a materialman's lien against that property, even though there wasn't a consensual lien. There's a statutory lien. Most everything that we deal with is a consensual lien, however. Okay? So we've talked about the bankruptcy estate, exempt property, non-exempt property. We've talked about creditors. They're either secured or they're unsecured. If they're secured, it's consensual, statutory, or judgment lien. And if it's consensual, we can either surrender the property, redeem the property, or reaffirm. Any questions on any of that? Already, without us finishing, you guys know more about bankruptcy than 90% of the people who live in the state. Okay. Dischargeability. This is where we get into the thick of bankruptcy is intended to allow honest debtors to get a fresh start. Things change in life. We have health problems. Incidentally, most of the bankruptcies that I've dealt with over the course of my 25-year career, at least 50% of the debt that's out there has something to do with health-related issues. Either medical bills as a result of the health-related issues, or having to quit your job to stay at home to take care of your spouse or your parent or a child that has a disability. Just flat out losing income because of you can't work 5 days a week anymore because your back only allows you to work a couple days a week, or so there's underlying very easy, and this isn't just me. This is very common. There was a college professor out of a little university back east. You probably heard of it. It's called Harvard. She did a long 10-year survey to determine why people file for bankruptcy, and she had her law school students extract data from courts across the country, and they established that the number one reason why people had to file for bankruptcy was because of medical-related issues. Top 5, medical, domestic relations issues. I mentioned before, we're now supporting 2 households on what we could barely support one on before. We have domestic relations attorney's fees. We've got counseling for our kids, et cetera, et cetera. It's just a financial boondoggle. Tax-related problems, businesses that go belly up, and just life changes, and we owe obligations we could afford to pay before and we can't afford to pay now. I lost my train of thought. Dischargeability. Thank you. Bankruptcy is intended to allow honest debtors to get a fresh start. It has a twofold purpose. An equitable distribution of available resources out to creditors. We talked about that before. A pro rata distribution. And for a fair treatment of the creditors. If I do things that are dishonorable, I shouldn't be able to receive a discharge at law. Honest debtors get a fresh start as the rule. So I can't discharge debts for fraud, embezzlement, or willful or malicious injuries. Fraud. If I go and just flat out bold-faced cheat somebody out of something, it's mine. I go to bankruptcy court. I'm not going to be able to discharge that in bankruptcy if the person upon whom the fraud was committed raises the issue. They have 60 days after the date first set for a meeting of creditors. I'll deal with that later, a continuum of how, like a calendar. Let me do it right now. Let's talk about a Chapter 7 bankruptcy. How does it work? You prepare your bankruptcy paperwork. You decide on the right timing, that we're going to talk about later. You file your case. The automatic stay goes into place. 5 weeks later, there's a hearing that you have to attend. It's called the meeting of creditors. I've already established creditors very rarely ever come to those, but you have to be there. Your trustee will be there. Your attorney will be there. 60 days from that date first set for the meeting of creditors is the time period that creditors have to raise a complaint for non-dischargeability. Now, when lawyers use the word complaint, the rest of the world uses the word lawsuit. So, when my wife hears the word complaint, it's the kids complaining about dinner or how unfair this was or whatever else. That's not how we're using complaint. A complaint for non-dischargeability is a lawsuit filed within the bankruptcy court that says, Your Honor, this debt by Dwayne shouldn't be discharged in Dwayne's bankruptcy. And then the pre-trial stuff goes on and the evidentiary stuff goes on, and then there's a trial and the judge will decide whether that debt survives the bankruptcy and whether they can continue to collect it. If Dwayne has committed fraud, it's going to survive the bankruptcy. If I embezzled from my employer or defalcated from my employer. The difference is whether or not, if someone entrusts me with something and I utilize that entrusted, I'm responsible for the bank account, I write the checks, then that's embezzlement. If they never entrusted me with it, but I found a way to get assets or take something, that's defalcation. Neither one of them are discharged in bankruptcy. And then also this bad person type of thing is I do something on purpose to harm somebody. Guy named Kenny used to always steal my lunch money when I was in school. So I'm driving past Kenny's house, I hydroplane, my car swirls out of control, and I shave off a brand new tree that he's planted. That's negligence, and I can discharge that in bankruptcy. But if I see Kenny's house and I see Kenny and I say, I'm going to teach him a lesson, and I drive into his yard, shave off his tree, back on the street and keep going, that was willful, probably even malicious, and I won't be able to discharge that debt. I can't discharge debts for child support or alimony payments. There's reasons why those are ordered. They don't even belong. Child support doesn't belong to the person I owe it to. It belongs to my child. Okay, I can't discharge child support nor alimony payments, nor even the attorney's fees that were awarded to my spouse. I'm happily married, by the way, but I'm just using an example. I'm happily married. I wish I could say my wife were. But anyway, I'll be here all weekend. Jokes won't get any better. No, I think my wife is somewhat happily married. Okay, relationships are difficult things, but so that would take us all afternoon. I have an obligation And if the judge ordered me to pay her attorney's fees, those are in the nature of support and maintenance, and I cannot discharge those as well either. I should have said. Okay, we can't discharge most taxes, most student loans. They just survive the bankruptcy. Credit card companies could come in and argue non-dischargeability based on false representation. And they're going to have to prove that we incurred the debt not intending to repay it for some reason. False representation doesn't take as much to prove as fraud does. Let me look at my list. I've only been doing this 25 years, but I want to make sure I don't forget. Oh, DUI obligations, they're going to stick. Criminal fines and penalties we can't discharge. Divorce settlements, criminal restitution, I got pretty close. You're going to have to give me those. So not everything can be erased in bankruptcy, but the vast majority of the debts that I've ever filed bankruptcy for my clients on have been discharged. Questions about dischargeability? No, yes, kind of. Okay, let's go ahead and move on to timing issues. Now, let's talk about Chapter 7 and how it works. We're going to go back to this sheet here. I've got them laying all over the place. Chapter 7, bankruptcy. Oh, I could have used a little promissory note thing on this form. I forgot that I used that for teaching law school. Okay, Chapter 7, liquidation bankruptcy. I prepare documents, my bankruptcy petition, my schedule of assets and liabilities, my statement of intentions. What am I going to do with my secured creditors? Am I going to give them the stuff back or agree to keep paying for it? I have to do what's called a credit counseling certificate. You go and speak with a credit counselor, and they will issue a certificate indicating whether or not you qualify for bankruptcy or not. Once all these documents are prepared, I left off the statement of financial affairs. You indicate what's been going on in your financial life for the last 3 years. These documents are not terribly complicated, but you need to get things in the right place, because if you claim an asset but don't list it as exempt, it doesn't come out of the basket. The trustee can take it. If you forget to list a liability, they're not going to be discharged. If you forget to list an asset and it was a rug in your kitchen, not that big a deal for some trustees. I had a trustee raise an issue because a client failed to list a bathroom rug and an umbrella. They were really trying to extort a settlement, but that's neither here nor there. There were other things they were saying, but I was, are you kidding me? They get that nitty picky. That's the rattlesnake example. We've got a trustee that is an adversary. We need to know how to weave through that complicated stuff, and that's why you got to get some advice.
Well, how would they know if you don't list this stuff unless they come to your house?
That is a great question. I've had clients ask me. Trustees can come to my clients' homes. They don't. Over the years, I've numbered all my interview sheets. I've sat across the desk from 25,000 families, small businesses, or individuals. I have over 25,000 interview sheets. So I've seen lots of stuff that can come up. I've been attorney of record on over 6,000 cases in bankruptcy. So not everybody needs bankruptcy. Not everybody needs debt relief at all. They just, they got a good defense on their lawsuit, and I'll send them out to do that. But clients have asked me, how will trustees even know? Because you're going to tell them, because you're swearing under oath that it's true and correct to the best of your knowledge and belief, because I've already asked you questions. You're going to fill out a packet for my office that is one of the more complex bankruptcy packets in the country. I tend to think it's the best bankruptcy packet in the country, but I'm just, prejudiced, biased. But this is a question and answer session that I will sit and meet with a client for 15, 30 minutes to get a basic idea of what's going on, so I can give a basic idea of what I think I would do if I woke up in their shoes. But then I hand them this packet and ask them to fill out, and it turns every single stone over that I would need to know on how the bankruptcy court's going to look at this, how the bankruptcy trustees are going to look at this, what you should do, what timing should happen out there. For example, in the statement of financial affairs, you have to disclose any assets you've conveyed away in the last 2 years. If you've conveyed something away for less than fair market value, the trustee in bankruptcy can reverse that transfer, get it back from the person that you transferred it to, compensate them for whatever they did pay you. Sometimes there's just out and out transfers. It's called a fraudulent conveyance. I don't owe this person any money. I have a quad. I don't want a creditor to take it. Bankruptcy or no bankruptcy. I transfer that quad for free to that person. It's called a fraudulent conveyance. The trustee in bankruptcy can reverse that transfer in a heartbeat. And how will they know about the transfer? Because we're testifying under oath that our paperwork is true and correct. And any transfer in the last 2 years has to be disclosed. Now, there's also what are called preferential transfers. I preferred one creditor over another. I owe my mom $4,000. I really owe her. I have a car that's worth about $4,000, but she's not secured by it. She doesn't have a lien on it. If I transfer that car to my mom within a year before filing for bankruptcy, it's called a preferential transfer. I did kind of address this at the very top here. It says assets owned at filing going to the bankruptcy estate. Oh. Fraudulent conveyances, anything in the last 6 years. Preferential transfers, anything within 1 year to what are called insiders, a family member's an insider, or 90 days to anybody else. So if I transferred something to a legitimate debt, let's say I paid a $4,000 credit card off because it was related to my employer and I didn't want my employer to know about the bankruptcy or whatever, the trustee can come back and make that credit card company cough that $4,000 back up if I paid them within 90 days before filing for bankruptcy. Preferential transfers, fraudulent conveyances. When you file for bankruptcy, you want the relief that comes from filing for bankruptcy. You don't want to be looking over your shoulder to see if the trustee or the court or somebody's going to revoke your discharge. You cheat yourself of the most important part of a bankruptcy if you don't list all of your assets. Schedule all your assets, schedule all your liabilities. Okay, so we filed a Chapter 7. We've gotten to the claims bar date, the last day that they can file a complaint for non-dischargeability. It's not all creditors that have to file a complaint for non-dischargeability. Child support, alimony payments, they don't have to file a complaint for non-dischargeability. It just survives bankruptcy. Taxes just survive bankruptcy. Now, I'll take a proactive position. If I have a client who owes taxes and they might or might not be discharged, then we'll file that lawsuit within those 60 days to get a predicate or something before the judge for the judge to determine if the 2008, 9, and 10 taxes are discharged, even if the 2011, 12, and 13 aren't. That way, the IRS can't come back later on and say, well, none of the taxes were discharged. And then they say, well, my attorney said that those would be. Well, your attorney didn't know what he was talking about. I don't get to determine whether something's dischargeable or not. I just get a chance to look and see what the law is and apply the law. So I will advise my clients when there's a significant amount of taxes on years that we think are dischargeable, that they hire me in addition to the bankruptcy to file a lawsuit against the IRS to get that an order signed by the judge that says, don't ever try to come back and collect on these taxes, levy wages, seize assets, or anything like this. Okay.
So some taxes are dischargeable.
Some taxes are dischargeable. It is a very, very, if the complicated wicket that my rattlesnake friend was in with regard to compared to a bankruptcy, I mean, it's 5 times more complicated on the dischargeability of taxes in bankruptcy. There's probably about 6 or 8 attorneys in the state that I would have confidence that could walk you through the dischargeability of taxes in bankruptcy right every time. Okay? Incidentally, if you own a business, you do not want to file a Chapter 7 bankruptcy unless it's a personal service type of a business. If you have a business that requires capital or equipment or some sort of asset that you can't do your business without, then you don't want to file a Chapter 7 liquidation because the trustees are going to shut that business down because they have an exposure. A personal service business like my own, I practice law. I'm fine if I close down my law corporation, file a bankruptcy, and start up a new one. Anything that was existing, any accounts receivables, the trustee administers those assets in my bankruptcy estate, and that's fine. For the benefit of my creditors, that's fair. But I want to start a new entity because I don't want the trustee saying that work I did post-petition is something I have to pay into the bankruptcy estate because it was a business that was owned by me. On my list of assets, I would have to list Farnsworth Law Offices Incorporated. Well, I own the stock of it when I filed the bankruptcy. The trustee in bankruptcy became the owner. There's no exemption for stock. You'll look at the exemption list all day long. Or if it's an LLC, there's no exemption for my interests in the ownership interest in that LLC. So the trustee takes ownership. If I keep doing work in that LLC, it's really the estate's money, not mine. And if I take a salary, I didn't get permission from the court to be appointed as a professional, blah, blah, blah. So if you own a business and it's a personal service business, you close that down, you file a bankruptcy, you open a new business up. Otherwise, if it's a business that has equipment that you need, we look more to Chapter 13, and we'll talk about that in a few minutes, why that works. We have to compensate unsecured creditors in a Chapter 13 for what they would have received in a Chapter 7 liquidation, and that's what makes it fair. If the trustee would have taken my accounts receivable and my non-exempt assets and distributed those $15,000 out to my creditors, when I file a Chapter 13, I just have to make sure that my unsecured creditors receive $15,000 over the 5 years of my plan. The reason I paused is I realized this is the part of the day where I start talking real fast because I know there's a lot to be, and that's why we're recording this. Okay, Chapter 7 liquidation bankruptcy usually takes about 6 months to complete. The vast majority of all the debts that we list in the bankruptcy are discharged. We can't discharge student loans. That's the one I didn't do. I knew there was one on that list. I said most student loans. We can't discharge most student loans, and it's even worse. And the problem with that is it makes student loan creditors worse collectors than the IRS has ever dreamt of being. They just treat people like dirt. And they can because they know the debt doesn't go anywhere. There are exceptions. You can discharge student loans if you can prove undue hardship. That's an incredibly difficult piece of litigation to master, and usually you don't win it. And if you do lose it, they're hiring the student loan attorneys, collection groups, student loan creditors are hiring big fancy lawyers downtown. If you lose it, you got $20,000 more debt, the attorney's fees that get added to the student loan. It's usually just not worth it. Okay, let's switch and shift, that was a combined word, to Chapter 13. Because my continuum was, remember, don't do anything, pay them everything, negotiate with them a settlement, a debt management plan. Chapter 13, Chapter 7, liquidation bankruptcy. Okay, Chapter 13. I love Chapter 13s. No, I just that. Chapter 13 is a tool in my quiver an arrow in my quiver that I can pull out of my toolbox and use if we need to, and it comes in real handy when we don't want to lose assets that we would lose in a Chapter 7, or when there's debts that are not dischargeable in a Chapter 7 that could be discharged in a Chapter 13. It's called super dischargeability. We can use it when there's a timing issue. We can use it when when we're going to talk about timing issues, we can use it when we just simply want to pay everybody back, but we can't afford to pay everybody now. I had a client who had $100,000 worth of unsecured debt, but the interest was killing him. It was $25,000 a year, $2,000 a month. He said, Dwayne, I could pay this all off if they just stop the interest, but they won't stop the interest. We filed a Chapter 13. In Chapter 13, the interest stops. And we paid off the $100,000 worth of unsecured debt. What did that allow him to do? Stop getting calls and garnishments and threats and litigation, and it let him focus on his job. And for that reason, the Chapter 13 on his Chapter 13 on his credit report was worth it to him. You look like you were going to have a question. No, you're just thinking. Okay, Ricky. Okay, so let's talk about a Chapter 13. It's on the same sheet. It's on the other side. There are 5 tests. I'm going to go through them so very quickly because we don't have time to go through in depth. But the first test is called the median income test. If you have a household of 2, your household will be compared to the median income for a household of 2 in the state of Arizona based on the U.S. Census Bureau's statistics. What this means is if you are under median, which for a household of 2 is about $48,000, if your total household gross income over the last 6 months divided by 6 multiplied times 12, we've annualized it then. If your total median household annual income is over, if your income, actual income, averaged income, annualized income is over the median income for a household of your size, then you don't qualify for Chapter 7 liquidation bankruptcy, unless you pass the means test. The means test is very complicated, but to simplify it, your gross income over the last 6 months divided by 6 is your monthly average gross. Subtract from that the reasonable living expenses that the IRS allows if they're trying to collect taxes from you. Those include tax withholdings. Those include insurance and household expenses and child support and alimony payments and this type of stuff. Also, if you subtract from that gross income number your secured debts, like your car payments and your house payments, it leaves a dollar amount. And if it leaves enough for you to be able to pay 1/4 of your unsecured debt in a 60-month period of time, then you don't qualify for a Chapter 7 bankruptcy. You'd need to do a Chapter 13. If it allows you to pay $200 or more for 60 months. You don't qualify for Chapter 7, you'd need to do a Chapter 13. That's why it's called the means test. Do you have the means or the ability to pay something back to your unsecured creditors? The next test is the disposable income test. Very simply, my net take-home pay is $3,500. My reasonable living expenses are $3,200. That leaves me $300 a month disposable income. That's what I would pay over the life of my plan. The yield test, I jumped over test. I jumped over the best interest of the creditors test. I mentioned that test earlier. That test says whatever an unsecured creditor would have received if a Chapter 7 bankruptcy had been filed and the trustee liquidated my assets, in a Chapter 13, those unsecured creditors had to be treated as fairly. So the $15,000 they would have gotten had my boat and my quad been liquidated, I can keep my boat and my quad in a Chapter 13, but I have to compensate unsecured creditors for keeping those assets that otherwise would have been liquidated. Now, finally, the yield test. This is the heart and soul of a Chapter 13. Yes. No, still thinking, okay? When I see your mind, your eyes are you have your mind moving. Okay, this is the heart and soul of a Chapter 13. The yield test. There's certain things we have to pay. We have to pay back child support if we owe any. We cure mortgage arrears or car arrears on a car if we're going to keep it. We cure homeowners association arrears if we're going to keep the home. We have to pay secured creditors the fair market value of their claim. Like a car, let's use my car example. If I owe $10,000 on a car, I used the wrong hands. If I owe $10,000 on a car and it's worth $6,000, I have a net negative equity of $4,000. If I file a Chapter 7, I might be able to negotiate something here, but they may just say give the car back or reaffirm on the $10,000. If I file a Chapter 13, and if it's been more than 30 months, 2.5 years since I financed that car, the judge will allow us to take that $4,000 that's unsecured and treat it like an unsecured. We reclassify it like an unsecured creditor, and we pay the $6,000 with interest. Okay? Or we pay the $350 on the vacuum example. It's just kind of like redeeming over a period of time. Okay, how much time do we have, Noah?
Oh, wow. 15 minutes.
Oh, 15 minutes. We can get there in 15 minutes. We also have to pay, under the yield test, priority taxes. Priority taxes are taxes that became due and payable as an income tax within the last 3 years. Now, we might also have to pay taxes as a secured creditor. As you saw, the secured creditor, we have to pay the fair market value of the claim if the IRS or the Department of Revenue had a lien that they had filed, a statutory lien that they'd filed against us in the county recorder's office. So priority taxes, we also have to pay child support and spousal maintenance because they're a priority debt as well. So any priority debt has to be paid through the plan. Unsecured creditors have to be paid what they would have been paid under the best interest creditors test. There's administrative costs like attorney's fees, court costs, and then there's also trustees' fees. It's a different trustee. The Chapter 7 trustee's job is to liquidate assets. Chapter 13 trustee's job is to gather the resources as they come in, make sure the Chapter 13 plan works, and then distribute the proceeds under the order confirmed by the judge. Chapter 13 plan. Most Chapter 13 plans, the attorney's fees are included in the Chapter 13 plan. I mentioned earlier the paid in full plans or the paid in full. Anybody that gets paid in full, their motivation isn't to be working for you anymore. That's just the way life is. So when we do a Chapter 13, we ask our clients to pay the court's filing fee at the outset of the case, and about $500 up front for us to be able to get the case prepared, filed, work the case through confirmation, and then once we get everybody to agree to the plan, the judge will order that we be paid based on whatever work we had to do in the plan. Chapter 13 plan is very complicated. There are attorneys who will not even do Chapter 13s because they're a lot more work. They're not as profitable as a Chapter 7 that you're in and you're out and you're done. But the reality is when someone comes into my office, I need to be able to offer them the full array of what's available to them as an option. And I begin with no bankruptcy at all. What would I do to avoid bankruptcy? We still prepare bankruptcy so we can explain to the trustees, so we can explain to the creditors what would happen under bankruptcy and why it's in their better interest to accept 30 or 40 cents on the dollar on this credit card debt or something. But it's never too late. We were talking about over the break. It's never too late to negotiate a settlement. When the creditor's trying to collect, when it's been turned over to an attorney, when the attorney's already sued, when it's already in litigation, after there's a judgment, during collection, post-judgment, before a bankruptcy, during a bankruptcy, there's never too late to try to get the creditor to come to the table and realize that you're better off and they're better off if we can come and negotiate some win-win situation. Okay, a Chapter 13 bankruptcy usually takes about 36 to 60 months to complete. If you pass the median income test, you can do a 36-month, 3-year Chapter 13 plan. But if you fail the median income test, it has to be a 60-month plan. If you fail the median income test but pass the means test, you can still do a Chapter 7 bankruptcy, but you wouldn't be able to do a 36-month Chapter 13. You'd have to do a 60-month Chapter 13. Chapter 13 bankruptcy, the timelines are pretty much the same, except once we get past the meter creditors. Get the case prepared, all the documents prepared accurately. File it with the court. The automatic stay goes into place. Trustee has a questionnaire they send out. There's a meeting of creditors you have to attend. Someone from your bankruptcy office, lawyer's office will be there present with you. After that, we go into a period of time that creditors are going to file proofs of claim, objections to the plan. The trustee's going to file a trustee's recommendation. It'll take us 8-10 months to get the case confirmed, signed off by the creditor, signed off by the judge, and then the monies that you've been paying since month 1 start flowing out to your creditors. Again, timing issues. Sometimes you'll file a Chapter 13 bankruptcy if you're not eligible to file a Chapter 7 bankruptcy. Eligibility for Chapter 7, if you fail the median income test and the means test, you're not eligible for a Chapter 7, so you'd file a 13. If you filed a Chapter 7 bankruptcy within the last 8 years and that filing resulted in a discharge, you're not eligible for a Chapter 7, but if it's been more than 4 years, you are eligible for a Chapter 13. You're not eligible to file a Chapter 7 or 13 bankruptcy if you've been involved in a previous bankruptcy within the last 4 years, and the automatic stay won't go into place on a subsequently filed bankruptcy that you've been in a bankruptcy within the last year. If it's your second bankruptcy, the automatic stay only lasts for 30 days instead of indefinitely. If you've been in 2 bankruptcies or more in the last year, and there's a reason why that could happen, then you get no automatic stay. You have to go in and file a motion to impose the stay immediately. Why would that happen? You filed a bankruptcy on your own, you didn't file the right documents, it got dismissed. Then you filed again, but you didn't attend a meeting of creditors and it got dismissed again. I mean, there's reasons why it could, but when I have clients, we spend a long time making sure all the documents are ready. So I don't want that first strike. I don't want to even get toward we're on the second or potentially the third strike to not have the automatic stay should be protected very, very, very carefully. Okay, so we file a Chapter 13 bankruptcy. What does that mean? It means that the creditors have the automatic stay in place. They can't sue, garnish, seize property. They can ask for the bankruptcy case to be dismissed because the plan isn't sufficiently funded to take care of all of these things that are under the yield test. If all these things added up under the yield test come to $30,000, we divide 30 by 60 months, and that's $500 a month. But remember, our disposable income was only $300 a month. We can't fund a $500 a month plan with $300 a month. So Chapter 13s aren't always feasible. Well, what if I'm not eligible for Chapter 7, but my Chapter 13 isn't feasible? Doesn't happen often, but it could happen. Then we wait. That's the timing element. We wait. This 6-month window I've talked about determines how much your plan payment might need to be, or if you even qualify. Well, if you recently were laid off, you're an $80,000 a year annualized income, then you don't qualify for Chapter 7 now, but you might qualify if the 6-month window is from now until you find a job. Okay. The timing has become one of the more complicated areas of deciding when to file, even if you decide that you need to file. And if you need to file, whether it should be a Chapter 7 or a Chapter 13, then the most complicated element is I've decided to file X or Y, when should I file? Timing wasn't always a big thing before 2005, but it became a big thing. Okay, now we're getting down to the really last few minutes. Is there anything about bankruptcy, Chapter 7, Chapter 13, the advantages, the disadvantages, the pros and the cons, what it means to be a secured creditor, an unsecured creditor, a priority claimant, what the bankruptcy estate is, what goes into the estate, what I can protect, what can't be protected? Is there something that comes to mind just hypothetically, generically, specifically, personally, individually? Okay, we're going to go into super fast running mode. I've produced a video, or a series of videos, and I'm in the process of producing a white paper or a lead magnet or a, what do you call it, a report that's called 10 Things Everyone Should Know Before They File for Bankruptcy. So I'm just going to use this report, and I'm just going to start busting through. But I want you to interrupt me if anywhere along the line you go, oh yeah, I remember there was a question. Okay, here we go. What are your debt relief options? We did that, the continuum. You're judgment proof. Nobody can come and take anything from you. Don't do anything. Pay your debts in full. Negotiate your debts and pay less. Borrow money from friends, family. Sell something if you have to, if it makes it happen. Debt management plan, Chapter 13, reorganization, Chapter 7, liquidation, bankruptcy. When you file for bankruptcy, some of your assets are protected. Those are the exempt assets. Personal property, cars, tools of the trade, household goods, furniture, clothing, accounts, pets, these types of things. Eligibility to file for bankruptcy, 8-year test, 8-year rule, 4-year rule. 8 years if you file the Chapter 7 bankruptcy before, 4 years if you file a Chapter 13 before, or if you want to file a Chapter 13 after a Chapter 7 that received a discharge. The means test we talked about. 707B abuse. We didn't talk about that. If your case is not primarily consumer, in other words, it's a business-related matter. I had a doctor who made tons of money. He had money he could pay everybody, but he was involved just as a boondoggle with a winery up in the state of Washington that it was just sucking him dry. This issue of eligibility to file for bankruptcy was a non-issue. He was eligible because it was a business-related debt. He could discharge. He was still subject to the rules of his personal property, but he could discharge the debt even though he had the ability or the means to pay something back over the next 60 months. 109G, eligibility. You're not eligible to file for bankruptcy if you willfully failed to abide by a court order in a previous case. So a judge told you to do something and you didn't do it. For 180 days, you're not eligible to file for bankruptcy. If you have a motion for relief from the automatic stay on a piece of property and you file a voluntary motion to dismiss, the combination of those two, kind of an alloy, means you're not eligible to file a bankruptcy for 6 months. It allows the creditors to have some room to do whatever they were wanting to do on that motion for relief from stay. Eligibility, timing. There's eligibility issues, asset protection issues. For example, you might need to sell some assets. That's a timing issue because you need the money to cure your mortgage or to buy a non-exempt or an exempt asset that you're going to need, like a car or something like that. So that's a timing issue. Debt forgiveness. Some taxes are dischargeable. Some things are dischargeable if the period of time has expired. If it hasn't expired, wait until that time has expired. Bankruptcy estate issues. We talked about preferences and fraudulent conveyances. We'll wait, so it's been more than 2 years from the time that we conveyed the quad to my friend, or more than a year since the time I paid my mom the $4,000 that I really owed her. These are more timing issues. When you file, you must always list all of your property, all of your real estate, no matter where it's located, even out of the country. You must list all your tangible personal property, even if it's an heirloom or something that there's some things that people just forget to list. Something my great-granddad left me and 32 of my other, his other great-grandchildren. It's important that you list bank accounts that have been laying fallow or things that you're on with other people. If you're on real estate or bank accounts with other people, your name's on it. It potentially is a very dangerous issue. I've had clients who haven't thought about that, and we've had to actually unwind those transactions before it made sense to file the bankruptcy. Intangible assets are frequently forgotten about. The right to sue, for example, a personal injury claim. You can't pick it up like it's a calculator or a car or something like this. It's called, the right to sue is called a chosen action. And if I file for bankruptcy, it's no longer my chosen action. It belongs to the bankruptcy estate because it's nowhere on your exemption list. When you file for bankruptcy, you must list all your debts. You can't leave family members off or other creditors off that you just don't want to include in the bankruptcy. They must all be listed. Forgotten or lost creditors. You need to go to a lot of trouble to make sure you list everybody because if they're not listed, they won't be discharged. Go into your credit reports, a good place to get some of those. Not all debt will be discharged. Fraud, embezzlement, willful injury, malicious injury, fines, penalties, homeowner association dues that come up post-petition, taxes, priority tax returns, child support, DUI, criminal, most student loans. We're at number 8 of 10. Security interests or liens will survive bankruptcy. We talk about secured creditors. Their liens survive. So we would either have to give them the asset back, pay them the fair market value of it, or reaffirm on the debt. Or pay it through a Chapter 13 bankruptcy. What happens when you file bankruptcy? The automatic stay goes into place. A bankruptcy estate is created. There's a meeting of creditors. Creditors will file motions to dismiss your case, or they'll file motions for non-dischargeability. The complaints for non-dischargeability. A motion is just kind of, it's different than a complaint. Complaint's like a lawsuit. Motion is like, Your Honor, consider this. Let's take a look at this. And then finally, bankruptcy will not clear off or clean up your credit report. It'll add something to your credit report, but your credit report is an entirely different business than bankruptcy. We're trying to get creditors to back off so you can focus on your health, focus on your relationships, focus on providing for your family. What time is it?
10 o'clock.
11 o'clock.
Yeah.
Okay.
Sorry.
Well, that's perfect. So we've ended on time. And it was a little bit of a foot race toward the end. We'll send you the video. I think your email. I need to get everybody's email. We have a couple email addresses, but want to make sure we have your email address so that we can send you the link to the video. Your turn. Questions, concerns, complaints, or any threats that you'd like to make at this time? No? Yes?
Now, I've got a question for you. I've gotten to quite a mess. I lost my job on top of it. Good
sorry.
job, and believe me, I'm not going back to that good job anymore.
Yeah.
I got into a medical thing. I had my appendix out New Year's Eve and New Year's night.
May I suggest
The
that,
medical is killing me.
okay, maybe for personal items, I get uncomfortable. You guys are probably just fine. I get uncomfortable when it's personal items because attorney-client privilege and privacy rights. I would love to speak with you either by phone or in the office or just talk about your situation and answer.
Okay.
I'd rather deal with general questions here and then.
I'd like to get them off my back. That's
Okay.
the thing. That's the question.
I will look forward to either, when we get done here today, we could go downstairs and or we could stay upstairs or whatever and talk about your situation. I can tell you what I would see in your situation. You look like you were going to ask a question.
I was, and then it left my head.
I'm sorry, Diane.
That's okay, it'll come back. One of them that I had is, how does it work then after you go through a divorce if you have stuff with the median income? Because you're no longer 2 people, you're 1.
Okay. The median income test is based on the household. Wait, hey Collins, could you get a sheet of paper and so we can pass it around and make sure we have everybody's email address so we can send them this video? Okay. And incidentally, it's 11 o'clock. If somebody needs to leave, feel free to get up and go. But I respect your time and I want to make sure that we ended on time. But I can say I can be. So the median income test is based on your household regardless of any other income of the next spouse. So if what you're talking about is the 6-month window, we don't have to look back on that 6 months. They're trying to do a forward projection of what your ability would be to repay somebody. And if that marital union no longer exists, they're not going to make us use that pre-means test calculation. You're not responsible for that.
Can you file for bankruptcy during a divorce and still have your divorce completed, or do you have to wait till that bankruptcy is done?
It depends on how complicated. Most bankruptcy divorces are pretty straightforward and they'll be over in 3 or 4 or 5, 6 months. I'd usually recommend that you wait until after the divorce is completed to not monkey up the system. You can file a motion for relief from the automatic stay. It's just an extra step, and that gives the the divorce judge the ability to keep moving forward. But there are sometimes that advice does not hold true, and that is, for example, sometimes you want to file jointly to reduce your court filing fees or your attorney costs in bankruptcy. You can only file jointly when you're still married. You want to be careful about filing jointly because you'd be responsible for non-dischargeability for any issue that came up with your spouse as well. Now, here's the biggest thing, and that is If there's a marital property settlement that's ordered by the divorce judge, you cannot discharge that obligation in a bankruptcy proceeding under Chapter 7. So there is a reason sometimes to file bankruptcy before your divorce is final, because you don't want the divorce judge issue an order that you end up having to pay a marital obligation that otherwise you wouldn't have had to pay if you just filed for bankruptcy first. For example, the judge orders you to pay a specific credit card after the bankruptcy is filed. If you don't pay that credit card, your ex-spouse could come in on what's called an order to show cause and ask the divorce court to make you pay that credit card. Now, there's reasons, the defenses you can raise, but bankruptcy is like a snowflake. Every single case is different. Even though we can talk about some general terms, there's things that you really want to decide your timing, and filing jointly, filing separately, even if you're married. It's all an individual type of thing. Any other questions? Complaints, like I mentioned? Okay. Well, if we can get your email address from everybody, we'll send you the video. My office, I stand ready to meet with any of you individually and talk to you what I know about non-bankruptcy debt relief alternatives or bankruptcy debt relief alternatives and what would be best for you or your friend. The last time I did a seminar like this was in 2011 to non-attorneys. I have a seminar that I put on here to other attorneys that don't do bankruptcy law, but it's been a while. But a couple of the people were here just searching out options for a friend of theirs. So, I can still talk to you about your friend's options and be delighted to be a resource.
What is the stigma of trying to get something after a bankruptcy? How typically is it the length of time before you can purchase something?
Okay, so you're talking about how soon could I get credit to buy a car or a house or finance furniture? I have my personal value on this, and that is I hope my clients don't finance cars or credit cards. Houses is a whole other thing. But I just recommend that you not incur indebtedness in the future because it's not been a blessing to you in the past. But buying a house, none of us can go drop $110,000 on a house. I'd still save up 25% of what it would take to buy the house. So I instantly have an equity cushion that allows me to not pay the PMI insurance on my mortgage. But to answer your question directly, it depends on the lender. If you're looking to get an FHA or a VA loan, right now the rules are if it's been more than 2 years from the time that you filed your bankruptcy, you would be eligible for an FHA or a VA loan at a market rate of interest if you otherwise qualified. If your industry was safe, if your job was secure, if your debt to income ratio, all the other things they measure on everybody else anyway. With auto lenders, they'll send you, as soon as you file for bankruptcy, auto lenders will start sending you stuff, but they're not your friends. They're going to want 30% interest. It's usually just best. I just beg my clients to save up $200 a month for 30 months and go buy a $6,000 car that's 5 years old or 6 years old and just start saving money for the next car. But you will find that you'll be eligible for a market rate of interest, usually on something like that 4 years after you filed, if you keep your rent paid on time, your mortgage paid on time, your utility bills paid on time. There's an advantage to having a credit card that you use post-petition after you file to borrow money and pay against it. There's people who disagree with me on that, but it's all a matter of your FICO score. The only reason I'm really interested in your credit score at all is because your ability to get market rate insurance for your home and your car, and to be insured at all is dependent on your credit score these days. So
And typically your FICO score is shit after you file bankruptcy.
typically, it's barnyard excrement before you file bankruptcy. My wife doesn't let me use that word at home, so I have to be creative. But you make a point. Let's do the scale. If you've got a 725 score and you get some slow pays on your credit, you're going to drop down quite a bit. If you get a lawsuit, you're going to drop down quite a bit. You're going to maybe 50 or 60 points. If you get sued, a judgment, a garnishment, a repossession, those are all individually. If that's the first thing that happens, it's going to drop you 80 to 100 points and even more so, foreclosure, repossession. But all of them together, each of them is not going to drop you 100 points. You're not going to have, a 100 score. Nobody has that. So if you're out of the blue, you get a 725 and you file a bankruptcy, you're going to drop by 125 points. You're going to be down there in the below 600 range. But if you're already at a 660 and you file for bankruptcy, you're not dropping to 490. And it's all. So yes, it will affect your credit score, but there's already enough on there that's affecting your credit score that most of my clients, by that point, their credit score is in the 600s or high 500s anyway. But that's a great point. There's nothing magical about what I do. This is just what I do. It's just a matter of what is right under your circumstances. So thanks for coming. Stick around if you'd like. I'll speak individually with any of you. Give me a call at some other time if you like. Happy to be a resource. I didn't bring any cards up because I didn't want to be I didn't want to push myself upon you. You know where I am. You've got my email address. You've got, you know where we're located. I'm easy to find. If you have questions, bankruptcy, no bankruptcy, I'd be delighted to be a resource for you. Okay? Have a great Saturday.
Thank you.
Thanks for coming.